Before we jump in, I do earn a referral fee when you use the services and companies I demonstrate in the video, but there is no additional cost to you. I chose them because they're the best in the industry and you're safe with them.
Have you ever wondered what the Corporate Transparency Act is and how it might affect your business? Well, you're not alone. This piece of legislation, often abbreviated as CTA, has been the subject of much discussion in the corporate world. At its core, the CTA is a law that requires corporations and limited liability companies to disclose their beneficial owners to the Financial Crimes Enforcement Network, or FinCEN. It's a move aimed at preventing illicit activities such as money laundering and tax evasion that can often be hidden behind anonymous shell companies. In essence, it's about bringing a degree of transparency to the corporate landscape that hasn't been seen before. It's about holding companies accountable and ensuring that everyone plays by the rules. Intriguing, isn't it? Let's delve a bit deeper into the key points of the CTA. So, what are the main points of the Corporate Transparency Act that you should be aware of? Well, let's delve into this. The Corporate Transparency Act, or the CTA, is a piece of legislation that was established with the aim of combating illegal activities such as money laundering, tax evasion, and fraud. It does so by increasing transparency in the ownership of corporations and limited liability companies operating in the United States. The main requirement of the CTA is that businesses must disclose their beneficial owners to the Financial Crimes Enforcement Network, fondly known as FinCEN. A beneficial owner is anyone who directly or indirectly exercises substantial control over a company or owns 25% or more of the ownership interests of that company. This information must be updated annually or within a month of any changes in beneficial ownership. The purpose of the CTA is twofold. Firstly, it aims to prevent the misuse of companies for illicit purposes. Secondly, it's about assisting law enforcement in detecting, preventing, and punishing wrongdoings. By requiring the disclosure of beneficial owners, the CTA makes it more difficult for individuals and entities to hide illicit activities behind a veil of corporate secrecy. But what happens if you don't comply with the CTA? Well, let's just say it's not advisable. Non-compliance can result in hefty penalties, both civil and criminal. Businesses can be fined up to $500,000, and individuals can face fines and imprisonment of up to 2 years. So it's safe to say that compliance is not just a suggestion, but a necessity. It's important to note that the CTA doesn't apply to all businesses. Certain entities, such as publicly traded companies and banks, are exempt. The Act also doesn't apply to companies that have more than 20 employees, over $5 million in gross receipts or sales, and a physical presence in the United States. Now that we've covered the basics, you might be wondering if you need to comply with the CTA. So, does the Corporate Transparency Act apply to you and your business? Well, let's delve into that. The Corporate Transparency Act, or CTA, primarily applies to corporations, limited liability companies, and other similar entities created under the laws of a state or Indian tribe. It's applicable to companies that are registered to do business within the United States. However, it doesn't include all businesses. There are certain exemptions to keep in mind. For instance, larger companies, those with over 20 employees and over $5 million in gross receipts or sales, are exempt. The reasoning behind this exemption is that these larger businesses are less likely to be shell companies, which the CTA is designed to target. In addition to size, the type of industry can also play a role in these exemptions. Companies in highly regulated industries, such as banks, credit unions, and investment companies, are exempt. This is because these businesses already provide similar information to federal agencies through other compliance regulations. But what about companies that already provide similar information to a federal agency? Well, they're exempt too. This includes entities that are registered with the Securities and Exchange Commission, have an operating license or a contract issued by a federal agency, or have over a certain number of shareholders. So, if your business falls into one of these categories, you might not need to comply with the CTA. However, it's always a good idea to double-check with a legal or financial advisor to be certain. Now, the CTA is not just about compliance. It's about promoting transparency and accountability in the business world. It's about reducing the potential for fraud and money laundering. And most importantly, it's about creating a level playing field for all businesses. So, whether your business needs to comply with the CTA or not, it's crucial to understand its implications. After all, transparency and accountability are good business practices that can enhance your company's reputation and performance. If you're still with us, you're probably wondering about the deadlines for CTA compliance. When are the deadlines for complying with the CTA? An excellent question, and one we're about to dive into. The Corporate Transparency Act, or CTA, is all about deadlines, and while it's not as exciting as a countdown to midnight on New Year's Eve, it's certainly just as crucial. So let's break it down. The CTA operates under the governance of the Financial Crimes Enforcement Network, commonly known as FinCEN. Now, the first thing you need to know is that the deadlines for reporting to FinCEN under the CTA vary depending on whether the entity in question is existing or new. Let's start with existing entities. Once the regulations are issued, these entities will have a runway of 2 years to comply. It's like being given a 2-year heads up to ensure all their ducks are in a row. It's a generous timeline, but don't be fooled, it's not a leisurely stroll. It's a deadline, and it's important to start preparations early to meet it. Now, on the flip side, we have new entities. They don't have the luxury of time that existing entities do. Instead, these new entities must report upon formation or registration. That's right, from the moment they enter the business world, they're on the clock. It's like stepping into the spotlight and having to perform right away. In both cases, whether an entity is existing or new, the importance of complying before the deadline cannot be overstated. Compliance is not just about following the law. It's about maintaining transparency, building trust, and fostering a business environment that is fair and just for all. So, whether you're an existing entity with a 2-year timeline or a new entity that needs to report immediately upon formation or registration, remember that the clock is ticking. And when it comes to the CTA, time is of the essence. All right, we've covered deadlines. Now let's talk about how to file a CTA report. You're on board with the CTA, but how do you go about filing a report? Well, let's break it down together. First, you need to gather all the necessary information. This includes the full legal name of the entity, the date of formation, the state or foreign country of formation, and the physical address of the entity. You also need to provide details about the beneficial owners of the entity, including their full legal names, birth dates, current residential or business street addresses, and a unique identifying number from an acceptable identification document, like a passport or driver's license. Once you've gathered all this information, it's time to submit your report. But where do you go to do that? The answer is the Financial Crimes Enforcement Network, or FinCEN, a bureau of the U.S. Department of the Treasury. You can access their online portal to submit your report. Now, you might be wondering, when should I file? The answer is pretty straightforward. If you're forming a new entity, you should file at the time of formation. If your entity already exists, you will have 2 years from the effective date of the regulations to submit your initial report. But filing a report isn't a one-time thing. You also need to update your report within 1 year of any change in the information you provided. This includes changes to beneficial ownership. Now, let's talk about what happens if you don't file. Non-compliance with the CTA can result in civil penalties of up to $500,000 and criminal penalties, including imprisonment for up to 2 years. So, it's essential to make sure you're staying on top of your reporting requirements, and there you have it. Filing a CTA report may seem daunting at first, but once you have all your information gathered and know where and when to file, it becomes a straightforward process. With the technicalities out of the way, let's address a final crucial question. Is the CTA constitutional? Is the Corporate Transparency Act actually constitutional? Now that's the million-dollar question. The constitutionality of the CTA is indeed a subject of much debate. On one side of the argument, proponents believe that the CTA is constitutional, asserting that it's a necessary measure to prevent illicit activities and ensure transparency in business operations. They argue that the act falls well within the government's authority to regulate commerce and protect the public from financial crimes. On the flip side, critics argue that the CTA may infringe on privacy rights, asserting that the requirement for businesses to disclose beneficial owners could potentially violate the Fourth Amendment's protection against unreasonable searches and seizures. It's important to note that this debate is ongoing, and only time will tell how the courts will rule on this issue. There you have it, a comprehensive overview of the Corporate Transparency Act. Remember, staying informed is the first step to staying compliant. Thanks for watching.